United States SEC files last-minute opening brief against Ripple challenging 2023 ruling. Ripple, a blockchain-based cross-border remittance provider, is expected to continue its years-long struggle with the United States Securities and Exchange Commission. On the other hand, Ripple's chief legal officer, Stuart Alderoty, has referred to the case as noise and is of the opinion that it will be dismissed during the administration that follows this one. With barely a few hours remaining before the deadline, the United States Securities and Exchange Commission has submitted its opening brief in an effort to accelerate its legal battle against Ripple, a blockchain-based digital payment network. The United States Court of Appeals for the Second Circuit issued an order in October of the previous year requiring the United States Securities and Exchange Commission versus Ripple and its executive brief to be submitted on or before January 15, 2025. If this deadline is not met, the appeal will be dismissed. According to documents filed with the court, the United States Securities and Exchange Commission is contesting the decision made by Judge Analisa Torres on July 13, 2023. XRP tokens were classed differently when they were distributed to regular investors and institutional investors, according to the court records, which disclose that the regulator intends to contest a portion of the order that was handed down by New York Judge Analisa Torres on July 13, 2023. It was clarified by the financial watchdog that Torres's conclusion, which states that profits cannot be expected until investors intentionally buy from the issuer, is contrary to both the applicable law and the undisputed facts. It was stressed by the Securities and Exchange Commission, SEC, that the verdict of the court violates fundamental securities regulations and creates an unsustainable discrepancy between the expectations of investors. The SEC contends that the decision is in direct opposition to the Howey test, which is a method that determines whether or not an asset is considered a security. In the document, it was demonstrated that the regulatory body persisted to accuse Ripple, its co-founder Christian Larson, and the chief executive officer of the business, Brad Garlinghouse, of violating the regulations governing the sale of XRP tokens to retail and institutional investors. A further criticism leveled by the commission was that the verdict differentiated between institutional investors and individual investors. The panel stated that Ripple's considerable marketing efforts were targeted at increasing the price of XRP. As stated in an article published on X, Ripple's chief legal officer Stuart Alderoty stated that the regulator's last-minute move was anticipated. According to the legal expert, the new court filing is a representation of the first arguments that were unsuccessful in the court processes that came before it. According to Alderoty, the legal action taken by the financial watchdog is nothing more than noise, and he voiced his conviction that the incoming administration, which will be led by President-elect Donald Trump, will eventually give up on the issue that has been going on for years. In addition to this, the legal expert emphasized that a new era of legislation that will assist the cryptocurrency business is about to begin, and that Ripple will flourish as a result. In addition, Ripple's chief executive officer, Brad Garlinghouse, made a statement regarding the legal action taken by the SEC, describing it as insanity. His criticism was directed against the regulator for repeatedly engaging in the same behavior while anticipating different outcomes. In the past, members of the Ripple community have leveled accusations against the United States Securities and Exchange Commission, claiming that the SEC is attempting to postpone the resolution of its legal struggle with Ripple. Users assert that the regulator was purposefully filing at the 11th hour in order to provide the defendants plus the entire cryptocurrency community with a high level of frustration. Investors are bullish about the prospective prognosis for XRP and the cryptocurrency market as a whole this year, despite the legal entanglements that have arisen. When compared to the top 10 largest cryptocurrencies in terms of market capitalization, XRP has emerged as the asset that has performed the best. Data from the cryptocurrency data aggregator CoinMarketCap indicates that XRP has increased by around 8% over the past 24 hours, bringing its 7-day gain to a total of 28.77%. With a market valuation of $173.7 billion and a 24-hour trading volume of $22.7 billion, the digital asset is now available for purchase for a retail price of $3.02. Following Bitcoin and Ethereum in terms of market value, the cryptocurrency currently holds the third spot among the greatest digital assets there are. The Securities and Exchange Commission of the United States has officially submitted an appeal in the continuing case that it is pursuing against Ripple. The SEC is attempting to consider the cryptocurrency XRP to be a security. Earlier, the United States District Court for the Southern District issued a finding that indicated that certain XRP sales to retail buyers did not violate securities laws. The Securities and Exchange Commission expressed its disagreement with this ruling in a brief that was submitted on Wednesday. In essence, the appeal challenges the distinction that the district court made between regular investors and institutional investors of the company. The district court reasoned that large investors plausibly expected profits from the efforts of others because Ripple suggested that its efforts would increase the price of XRP, the Securities and Exchange Commission stated. With regard to the objective investor standard that is stated in the Howey test, the Securities and Exchange Commission, SEC, contended that the district court's difference between the objectives of institutional investors and retail investors is incompatible. In addition to this, they asserted that it violates a key premise of federal securities regulations, which states that investors with less sophistication are just as capable of protection as investors with more sophistication. However, the district court made the mistaken determination that ordinary investors did not have the same expectation. This was due to the fact that they purchased XRP through crypto asset trading platforms, and as a result, they were unaware of whether the seller was Ripple, a Ripple affiliate, or someone else. By arguing that all sales of XRP are unregistered securities, the Securities and Exchange Commission, SEC, hopes to overturn the decision of the court that favored Ripple. You can expect the case to be sent back to the trial court if they prevail. There are reports going around that the Securities and Exchange Commission, SEC, under the Trump administration, would change its position on the regulation of cryptocurrencies. According to reports, there is a possibility that enforcement operations will be put on hold, which may result in settlements being reached more quickly and a move away from the concept of regulation by enforcement. It is anticipated that the next administration will bring more clarity and respect for the cryptocurrency business. This is due to the fact that the current Secretary Chair, Gary Gensler, is scheduled to step down the following week. The whole cryptocurrency industry is keeping a close eye on the current legal struggle that is taking place between the United States Securities and Exchange Commission, SEC, and Ripple, particularly as the deadline for the SEC's appeal draws near. There is a group called Brito that is dedicated to Arthur Brito, who was one of the co-founders of the XRP ledger. According to Brito, the SEC has until January 15, 2025 to submit its appeal brief in the Ripple case. In the event that the Securities and Exchange Commission is unable to reach this deadline, Brito posed the question on Twitter on the prospect of expulsion. After receiving Brito's request, Mark Fagel, a former attorney for the Securities and Exchange Commission, answered by claiming that the idea of an appeal being dismissed due to a missed deadline is implausible. Following up on the previous question, Brito inquired as to whether or not it is common practice for government agencies, such as the SEC, to postpone filings until the very last minute.